of jus dem generis. The Speaker, in exercising that discretion, has to look at what is specified in the standing orders as business which qualify to be subject matter of a special sitting. And since the other matters which are enumerated touch on issues which are stipulated in the Constitution, and they include matters like declaration of war, impeachment of the President or the Deputy President, unless it is business falling under the category stipulated in the standing orders. Or has got some constitutional relevance to what is specifically provided in the standing orders, then they would not qualify. Now, my Lord, again, we seek to persuade the court, if we were granted leave, that there was breach provisions in relation to business that was transacted in the National Assembly. Beginning with the fact that there was no public participation in relation to the bill as it was introduced in the National Assembly. I'm just focusing on what happened in the National Assembly. And the question of public participation is not a matter on which Parliament has an option. It's a constitutional requirement. Now, what form it takes, my Lord, again, that has to be dealt with on a case-to-case basis. It does not mean that members of the public must appear before Parliament or the Committee of Parliament. But in this instance, we're arguing there was no public participation at all. And therefore, there was a violation of the Constitution. And secondly, we will try to persuade your Lordship that by excluding the media and the public from special sittings, again, there was a violation of the Constitution, because the Constitution specifically requires that Parliament shall not exclude the public or the media from its proceedings. And for that, to that extent, the requirement that business be conducted in an open manner, that was also violated. Now, my Lord, again, the Constitution gives freedom of speech to members of Parliament, that when Parliament is in session, the members of Parliament are entitled to freedom of speech, but we will seek to show and demonstrate that in the manner in which the proceedings were conducted in the National Assembly, members were not able to exercise their freedom of speech, not just within the requirements of the Bill of Rights, but within the provisions of the Constitution that require how business is conducted. Freedom of speech of members of Parliament is a matter which is guaranteed and provided under the Constitution. And, my Lord, and normally when Parliament would invite public participation. These invitations would be public and they would be published in the media and so on for members of the public to be able to offer their views. Now, more importantly, my Lord, if and I don't want to take the court through this, but under the Fair Administration Action Act, there are provisions which are similar to the grounds on which we seek judicial review. They are set up in our statutory statement on page 10 of the application, of the statutory statement rather, the bigger volume. At the bottom, there's pagination running from page 1 to page 10. My Lord, there's paragraph 22, which we cite several violations of provisions of the Fair Administrative Action Act, some of them which are anchored in the Constitution and are similar to the arguments I have presented to you, but which, since they're anchored in the Constitution, a breach thereof would constitute an illegality and therefore amenable to judicial review. So on these grounds, my Lord, we pray that you grant the three orders that we prayed for, that the matter be satisfied as urgent and that this matter be heard during the current court vacation. And thirdly, that leave be granted to apply for orders of judicial review, and specifically the orders of Seshirora